Hello everyone, I'm Djandel Marbun. I'm a student of Master of Law at Batam International University, and the concentration is business law. The subject of my presentation today is international contract structure, and this is as a part of examination of commercial law and international contract subject for this semester. Before we continue to the main topic, I would like to thank my professor in this field, Ms. Rina Sharula, PhD, for her guidance during the last several months. Well, I will try to elaborate what is the international contract structure and will also break down in one international contract sample. Prior to going to the details of the contract, here is the outline or structure of the contract standard. 1. Title of contract. 2. Parties identity. 3. Declaration of agreement. 4. Terms and contract. 5. Object of contract. 6. Choice of law. It might be unit right principles, TISG, or the contract for the international sale of goods, or any laws applied. 7. Delivery of method. It might be letter of credit and so on. 8. Dispute settlement. It might be negotiation, mediation, and arbitration. 9. Force majeure. 10. Closing signature of parties and witnesses and appendices. Now we are moving to the contract of sales of printer Epson as the title. And also this is as an object of contract. Okay. Below is TAS Technology Private Limited, which is in principal office 10 UB Crescent number 5 up till 82, Ubi Tech Park, Lobby C, Singapore, represented by Long Hee Hong Lee by CEO. Hereinafter referred to as the seller on the first party. NPT Maju Bersama, having its principal office at Jalan Gajah Mada, Block B, number 23, Tiban Baru, Kupang Batam, Indonesia, postcode 29429, acting by Djandel Marbun, Chairman of the Board of the Directors, and hereinafter referred to as a buyer on the second party. Seller and buyer referred to also as the contracting party or separately each the contracting party, and this is in the structure of the contract as a party's identity. Have entered on the day, month, and years below pursuant to the United Nations Convention on Contract for the International Sale of Goods, hereinafter referred to Convention, into the following. And this is as a choice of law. Contract for the sale of goods. Subject matters of the contract. And this is as a declaration of agreement. The subject matter of this contract is particularly the obligation of the seller to deliver goods specified in the exhibit number 1 here to the buyer and to transfer the property in goods to the buyer under the terms and the condition here, and the obligation of the buyer to accept the delivered good from seller and to pay the agreed purchase price. Sale of goods, or we call it in the structure term of contract. 1. The seller hereby agrees to To deliver the buyer goods movable specified in exhibit number 1, here 2, or hereinafter referred to the two as the goods in the time, quality, quantity specified in the exhibit number 1, here 2. The buyer shall collect goods and pay seller for the goods for the purchase price specified in the article 3 hereof. Number 2, the seller fulfills his obligation to deliver the goods when the goods have been made available to the buyer and the place of business of the seller. The parties have agreed that the buyer shall arrange the carriage of the goods from place of business of the seller through a carrier, the name of which buyer shall notify seller. The seller shall arrange the loading of goods, and the goods shall be packed in the manner set forth in exhibit number 2. Unless otherwise expressly provided herein, the goods shall be packed in a manner adequate to protect the goods. Delivery method. 3. The seller shall deliver the goods to buyer carrier on 15 December 2021 during regular working hour from 8 a.m. to 16 hours. Seller shall notify buyer regarding delivery goods to carrier by email to Djandel to the following email or message sent to the phone number 081372271115. 4. The title in the goods shall pass to the buyer immediately upon delivery of goods to the buyer carrier. Risk of damage to or loss of the goods shall pass the buyer at the time of delivery. 5. The buyer hereby declares to receive all information regarding the goods necessary to arrange insurance coverage. 6. Seller shall send the buyer document related to the goods within 10 days after delivery of goods and at the buyer address set out in herein. Purchase price. 1. The buyer shall pay the seller the purchase price of the goods amounting 20,000 Singapore dollar hereinafter referred to as the purchase price. The purchase price shall be due upon the invoice issued and sent by the seller not later than 10 days from delivery and collection of goods by the buyer. The invoice shall be payable not later 20 days from the issue of the invoice by seller. 3. If the buyer fails to pay the purchase price, the seller shall have the right to default interest at the rate of 0.1% of the outstanding amount for each day of the default without prejudice to any claim for the damage pursuant to the Article 74 of the Convention. Product liability. The seller shall be liable for any lack of conformity in the goods which exists at the time when the risk passes to the buyer and which occurs within 24 months from the date of delivery of the goods by the buyer courier. The seller declares that the goods during a period of 24 months from the date of the collection by the buyer courier will remain fit for the purpose for which the goods would ordinarily by use or during this period will retain specified qualities, hereinafter referred to as the warranty period. 2. The seller shall not be responsible for the defect arising out of the failure to follow operation instruction, for the defect caused by improper storage of the good, where delivery for the defect caused by circumstances were beyond the reasonable control. 3. The buyer shall immediately upon delivery of the goods by the courier duly examine the goods and if the defect of goods were apparent upon the collection of goods, the buyer shall promptly give notice on this to the seller. 4. Should the buyer discover any defects during warranty period, the buyer shall give written notice of defect to the seller and not later than within 15 days, such as defect had been detected. In a written notice specifying the defect, he shall have the following option: replace of the defective goods by delivery of non-defective goods, demand to repair defective goods if the defects are repairable, demand a purchase price reduction or withdrawn from the contract. 5. The seller, upon receipt of notice from the buyer stating the defect, promptly shall give a written statement and reply whether he accepts the claim for defect or not. Exclusion of liability. For the standard contract structure, the force majeure will be in point number 9. But anyhow, this is not a must that in arrangement of the structure of the international contract. 1. A party is not liable for a failure to perform any of his obligation if he proves that the failure was due on an impediment beyond his control and that he could reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it or its consequences. The exemption provided by this article has an effect for the period during which the impediment exists. The non-performing party shall give prompt written notice to the other party of the reason for its failure to perform and the extent and duration of its inability to perform. Now we are moving to the next arbitration clause. This is as a dispute settlement. All the dispute resulting from this agreement or in conjunction with it will be decided finally in the arbitration procedure before one arbitrator, Dr. Muhammad Idwan Ghani, Sarjana Hukum, registered in the list of arbitrators of Singapore International Arbitration Center, 28 Maxwell Road, number 3, Unit 1, Chamber, Suite, Singapore, and appointed in accordance with Act number 216, year 1994, Call of Laws on Arbitration Procedure and Execution of Arbitration Award, and with the proceeding rule of Singapore Arbitration Center announced at its website as following. The parties authorities the arbitrators to settle dispute based on the principle of natural equity. Compensation for arbitration costs, including the expenses of the contractor parties, will be awarded by the arbitrator based on the principle of success in the dispute. Final provision. 1. This contract shall enter into force and shall take effect on the day when it is executed. 2. The contracting parties hereby agree that entering into this contract and performing duties under the contract have been duly approved by the relevant company bodies of the contracting parties in compliance with legal regulation, by laws, and other international regulation of the contracting parties, and no other approval or consent shall be required. 3. The contracting parties agree to respect the legitimate interest of the other party, shall conduct in accordance with the purpose of this contract, and shall not counteract such purpose, and they shall perform all legal and other action that may prove necessary to reach the purpose of the contract. 4. All documents in writing shall be mailed at the address of the contracting parties set forth in the heading of this contract, unless either of the contracting parties shall give a written notice to the party on changing its address. Whatever papers the delivery of which is required, assumed or is made available by this contract, and regardless of any other available way or law allowed by the legal regulation to prove such a delivery, shall be deemed to have been served if such had been delivered to the other contracting party at the address set forth in the heading of this contract, or at the address notice in written form by either contracting party to the other party. 5. Any changes of an amendment to this contract shall require a written form. If 6. If any provision of this contract is determined to be invalid or unenforceable, the validity or enforceability of the provision of either of this contract as neither a whole nor other provision will be affected unless such as invalid or unenforceable provision is severable. Contracting parties hereby agrees to supersede such invalid or unenforceable provision by a new valid enforceable provision that most closely matches the intent and the purpose of a green original provision. 7. This contract and relation arising from shall be governed by the law of the Republic of Singapore, particularly by the United Nations Convention on Contract for the International Sales of Goods. This contract had been made into duplicates where its contract parties shall retain on one copy each. For this number 7, maybe I will rephrase the choice of law is among the law applied, such as unit right principle, and here is the contract of international sales of goods from United States is applied also. And we may move to the next closing signature. Closing signature from each parties, and if there is also witnesses and appendices of this contract. Done in Singapore on 13 June 2021. Chas Technology Private Limited Hongli, signed. PT Maju Bersama S. Djandel Marbun, signed. And thank you. Thank you for your attention. See you next time. Thank you.